All right, we're back on the record at 10 a.m. The matter that is before the hearing board is an overview of Brown Act changes. The hearing board's attorney will provide relevant changes to the Brown Act from Senate Bill 707. So at this time, I would call on Ms. Michael to preface the presentation. But before that, there are several members of the hearing board who are participating, hearing board alternates participating remotely as well as in person. So we'll go ahead and turn the floor over to you, Ms. Michael, and off we go.
Good morning. And if possible, it would be fantastic if my colleague Dale Larson could be promoted to panelist. I know that he's going to be doing the second part of the presentation. Yes, okay. I think I had appeared before the hearing board maybe several years ago, but my name is Julia Michelle.
I'm sorry, Michelle, okay.
That's okay. That's a common misunderstanding. I'm an associate at Stromwasser and Wucher, which of course the board is familiar with. And I have prepared for you today a brief overview of the changes for the hearing board under the new Brown Act updates. So let me go ahead and try to share my screen. Okay, hopefully this is now visible for folks ahead. Please let me know if you can otherwise see it.
Well, hold on one second, Ms. Michelle. We can't see it just yet.
Oh, no.
Just to let you know, I can see it.
You can, okay.
AQMD IT, is Ms. Michelle and Mr. Larson able to share the screen?
Yes, sir. I see it on my screen here.
Okay, well, we can't see it in the hearing board.
Okay, just 1 second, please.
There we go. All right.
Okay.
Ms. Michelle and Mr. Larson, off you go.
That sounds good. So essentially what I'll be covering today are sort of 4 categories of changes that went into effect with SB 707. The first is remote participation using the now permanent ADA accommodation provisions. The second is a just cause participation provision that is going to be in effect for the next 3 years. The third is a quick reminder of the traditional teleconferencing requirements. And then the fourth are a couple of updates, mostly around social media. Okay, so the first thing, remote participation as an ADA accommodation. Essentially what SB 707 did was make permanent the ability for board members to be able to participate remotely as a reasonable accommodation for qualified ADA disabilities. As noted on the slide, there is no limit on the number of remote meetings for each board member per year, as we'll see with some of the other provisions. The requirements for a board member seeking to appear remotely using this subsection has really only a couple of requirements. First, they must use what's referred to as two-way conferencing so that there's both audio and video. The asterisk there is that, if they're depending on the individual specific disability, unless both of those are required unless the disability would prevent it. As also noted on the slide, the board members should note at the beginning of the meeting whether there are any adults in the room present with them at the remote location. The specific remote location where they are present is not required to be disclosed. So if they're in their house, they don't need to say that or provide the address. And then the third note up here is that the remote participation counts towards quorum as if physically present. Essentially, the way of thinking about the ADA accommodation provisions are that they are extremely liberal in allowing the person who's taking who's appearing pursuant to those provisions to be treated as though they were physically present. And this also comes into play later on in case the board seeks to use the teleconferencing provisions that require a specific number of individuals to be within the jurisdictional boundary of the district. That will make sense in a couple of minutes, I think. A couple of additional notes that are actually not on the slide. Number one, the individual is not required to list that they are seeking to appear remotely pursuant to this provision in advance of the hearing, so it doesn't need to appear on the agenda. And it also is not required to be listed in the minutes. And as I'll note in just a second, that is a little bit different for some of the other provisions. Next slide is, what is a qualifying disability? The definition for disability is borrowed from the ADA. As a physical or mental impairment that substantially limits one or more life activities of an individual, a record of having such an impairment, or being regarded as having such an impairment. So Dale will speak a little bit more about the form and policy that we have provided for the board's review, but essentially a board member seeking to appear pursuant to remotely pursuant to these subsections will make a request. The request will be confidential. In that request, we have a line for the individual to describe the limitation that makes remote participation necessary, but they do not need to provide a specific name of a diagnosis or condition for why they are seeking to appear remotely. There are sort of two steps to carrying this part of the Brown Act into effect that the board will need to undertake. The first is to adopt a written policy for evaluating and responding to ADA accommodation requests. This is, I think, was sent around the board maybe yesterday for review, and Dale will speak a little bit more about that as well. And then in addition, that policy will be posted on the hearing board's website where agendas are posted, so that any ADA related details are included with all meeting agendas. It should note too, and not to step on Dale's toes, he'll cover this more as well, but this could also be applicable for a member of the public who is seeking a reasonable accommodation. Okay, so now we're at the second. We moved past ADA accommodations. Now we're in the world of a just cause remote participation. SB 707 basically consolidated the previous emergency circumstances and just cause exceptions into a single single just cause exception for basically simplicity's sake. So I think the way of thinking about the just cause subsection is that these are things that are not necessarily situations you can foresee in advance, and they are sort of meant to be used sparingly, as we'll see, because the statute places a limitation on the number of times a member can rely on these exceptions. They are listed out in the statute and then also on the screen. The first, caregiving requires an individual to participate remotely. The caregiving is specifically related to a child, parent, grandparent, grandchild, sibling, spouse, or domestic partner. So Unfortunately, aunts and uncles are not among the listed individuals. Otherwise, you can think of it as being people in your kind of immediate family, in addition to grandparents and grandchildren. Contagious illness, that is pretty self-explanatory. Travel while on official business is another pretty self-explanatory one. The next one is a need that is related to a physical or mental condition that is not subject to the ADA provision. So basically, the idea here is that the ADA provision and this provision operate separately. So I think that that's a way of basically ensuring that somebody who does have a physical or mental condition, but maybe does not rise to the level of an ADA disability, that those individuals would still be able to participate remotely. An immunocompromised family member, the family members are exactly the same as the ones that I listed in the caregiving responsibility. So again, that is children, parents, grandparents, grandchildren, sibling, spouse, or domestic partner. So the next one is a physical or family medical emergency. That's hopefully pretty self-explanatory. And the last is a military obligation. There's some additional details in the statute about what that sort of entails. Specifically, it's because the individual is serving under official written orders for active duty, drill, annual training, or any other duty as required by a member of the California National Guard or United States Military Reserve organization that requires the individual to be at least 50 miles outside the boundaries of the local agency. So those are all in the statute. One quirk about the Just Cause remote participation provision is that there are these limits on the number of times an individual can appear remotely pursuant to these provisions. So as we've listed below, that means if the hearing board meets monthly or less frequently, that would only amount to essentially 2 meetings per year. If the body meets twice monthly, so every other week, then that would be lifted to 5 meetings per year. It's my understanding that the hearing board would probably fall into the first or second of those limits. There are some additional procedural requirements as it relates to the Just Cause remote participation provision. The member is asked to notify the board at the earliest opportunity of the need to participate remotely and provide a general description of the circumstances. That notification can happen at the beginning of a meeting if necessary. It's just as early as possible. The member must participate via both audio and video. So that's the same as the ADA reasonable accommodation provision. And also the same is that the individual must disclose whether there are any other adults present in the remote location. One thing that is different is that the meeting minutes must reflect that the member participated remotely and the specific just cause basis. So this would mean like a subsection of, the member needed to participate remotely because of military service. That specific subsection would be noted in the minutes. And then the final thing in bold here is that a quorum of the board is still required to be in person in a single location. Now, I'm anticipating some questions about what happens if you have kind of both of these if you have somebody participating under the ADA provision, and then also somebody who needs to participate remotely under the Just Cause remote provision. So this bold section is going to help us evaluate that. So essentially, the person who is participating remotely pursuant to the ADA provision will still be treated as though they were within that single location, as they're treated as being physically present. And finally, we still have the traditional teleconferencing, which I'm sure the board is a little bit more familiar with because this has been something that has been an option for several years. Under this method, each teleconference location must be identified in the agenda, and each location must be accessible to the public. So this is, not somebody joining remotely from their home. The agenda also must be posted at each teleconference location, and at least a quorum must participate from locations within the district's boundaries. One thing that is a little bit more liberal about this subsection is that there is, no limit on the number of times that it can be used per year. Social media. So let me just pause here and ask, how many folks, maybe by show of hands, use social media and specifically have posted anything related to their hearing board responsibilities or anything on the docket?
Ms. Michelle, I could speak for the entire hearing board. None.
Okay, well then this will be quite simple. It's in case folks change their mind and want to become, the next viral Instagram influencer, it would be helpful for them to understand that it is okay to use social media programs to discuss district matters, but there are some real cautionary points in the statute. The first is that a majority of the member cannot engage on the same topic on the platform. This is to avoid having a meeting without having an actual meeting where business is discussed. And then the second thing is that members cannot respond to or react to other members' posts on the same topic. So that would come into play, if somebody posted, something that they were excited about, and then another member liked it or gave a thumbs up, or I'm not actually familiar with all of the other ways you can respond on Snapchat or Facebook, but that's where that would be prohibited. Question time.
Dr. Pearman.
Oh,
No, it's okay. You Dr. Pearman today.
yeah, okay.
You got a JD. He's got a Juris Doctorate.
So you mentioned that if you would, the ADA person is deemed in a single location in terms of that aspect of the quorum being required to be in a single location under the just cause category. Now, would the same logic apply that under traditional teleconferencing where a quorum must be within the district boundaries, the ADA person is deemed within the district boundaries no matter where they are physically located?
Right.
Okay. And then in terms of the, I guess you call it the meeting minutes, we have what's called a minute order, which I think might be different than minutes as the statute reads. And this might be a question for the clerk, but I wasn't aware that we put the kind of detail they just mentioned about specific just cause basis in our minute orders. If not, do we have to start doing that, or is there a separate category of minutes that's different than our minute order that can be reflected in?
Well, we do put it in the minute order. We just, make a very brief statement that the person attended under the just cause exemption, due to medical or, we don't go into any detail, but we have been putting it on there.
Okay, great. And then is it, this might be just a question of best practices. I assume that the agency, or in this case, the clerk would keep track of the number of times the just cause is used in the calendar year. It's best practice to mention that every time it's number 3, number 5, number 6, so that we can keep track of that, or how is that handled generally, if you know?
Yeah, I mean, I definitely think it is, it would be helpful to have the clerk keeping track. I mean, I also think that ideally these just cause provisions are really not used that frequently. And so it would be on the board members as well to know, how many times that they've used one. That I think is particularly the case because of the number of the limitations are so pegged to the number of meetings that the board holds, which, as I understand, can fluctuate a bit. So I'm not sure if that's helpful. I honestly, I think that it would be really good for an individual board member to keep track of their own, and that we could also work with the clerk to ensure that, once that appears in a minutes, that there is a tracking of that as well.
Thank you.
And the clerk's office does keep track of the number of exemptions used by each board member.
Excellent. I should have let you speak first.
So just to kind of set the stage here and level set, the two biggest or largest concerns here really is the differentiation / bifurcation between just cause and ADA. So I really want the attorneys to expound upon this huge new development, so to speak, because this is, and Ms. Conacher Macklin knows this because she's worked on both sides of the table, in-house counsel as well as out-house counsel. And so rarely have elected officials or appointed officials use this ADA provision. So why don't the attorneys kind of underscore that point?
Sure. I mean, I think that, there have been, over the history of the Brown Act, some different views on whether or not how the ADA really applies. In the past, it was not quite as liberal as it is today. The idea is that having an ADA disability should not prevent a member from serving on, a board. And so the policy and the statute that we're working with now, that has been updated by SB 707, essentially adopts that logic as state policy by providing a much more liberal way for individuals who do have qualifying disabilities to participate fully in the process. As to how frequently these subsections are used, I honestly couldn't speak to that. I mean, I think that, because the law has now sort of formalized the Attorney General's previous policies, that, we may end up seeing more folks take advantage of these provisions. And I say take advantage, what I really mean is, use them pursuant to the entitlements that they are, justifiably given under the statute. So it could be that we see an uptick in these subsections being used.
Just a tiny bit more history too. The ADA has been around since 1980, 1981, something like that. So, in theory, there's always been a right under federal law to have a reasonable accommodation for a disability, but everyone's been afraid to apply that in the Brown Act context because the Brown Act has such stringent requirements and they don't want to get sued or when they're taking an action on something. And then a few years ago, the Attorney General issued an opinion where someone asked the Attorney General, can you appear remotely as a reasonable accommodation under the ADA? And the Attorney General said, yes, a body should make that available, which then just kind of created some confusion among the public in California because they said, well, we've got these stringent requirements under the Brown Act and the AG is saying we can do something else under the ADA. And so there was a bit of a limbo period where people weren't sure exactly how to incorporate the AG's advice. And then so the legislature late last year jumped in to clarify and sort of codify what the AG had put into his opinion, saying, yeah, it's in the Brown Act now too, that this would be a basis to appear remotely. And, and the part of the goal of the policy you're going to look at in a minute is to make clear when someone is appearing via an ADA, a reasonable accommodation, which would distinguish that from the just cause provision.
Ms. Conacher Macklin, excuse me, Ms. Verdugo-Peralta, the floor is yours.
Thank you, Mr. Chair. Okay, so I want to be absolutely clear on this since I am the disabled person here. So I need to fill out the form, or any disabled person needs to fill out the form. So there will not be any limit of how many times. I don't have to limit to 7. And what I really want to be clear on is I no longer need to request a public location, i.e. the City Hall, who has been so generous, City of Temecula has been so generous in providing a room that is open to the public. And lastly, that I will be considered as present at the facility at the AQMD so that my fellow board members can use Just Cause if need be. Is that all correct?
That's all correct, so long as you make a request for reasonable accommodation under the ADA and your request is approved by the chair pursuant to a policy.
Okay, who has that form?
But Ms. Verdugo Peralta, we're going to get to that in 1 second.
Okay, thank
We
you.
got you covered. We got you covered. So
Thank
just on the mechanics, folks, just so we're clear, Mr. Larson, kind of open up the door. So let us walk through. All right. Essentially, Ms. Verdugo Peralta, since she presented herself as an example, we'll go ahead and use her, and I hope she does not mind.
I don't mind at all.
So essentially, ADA is stating she's sitting a few clicks from me. She's literally sitting on the dais in Temecula. And the four of us would then be able to negotiate who's out on what day, if just cause is used, et cetera, et cetera, et cetera. Is that correct, Mr. Larson and Ms. Michelle?
Yeah, that's correct. And I'll read from, I have the Brown Act up in front of me. This is from section 54953 of the Government Code, subdivision C3. And it reads, remote participation under this subdivision, which is about the ADA accommodation, shall be treated as in-person attendance at the physical meeting location for all purposes, including any requirement that a quorum of the legislative body participate from any particular location.
So what that sounds to me, it's almost like in the charter school provision, Mr. Conacher-Macklin, it says it's deemed approved. So it appears as if, I know Ms. Thomas is looking, you have some comments, Ms. Thomas?
No, I just wanted to give a real life
Oh, go right ahead, go right ahead,
situation,
go right
because
ahead.
I understand where, she's counted as being at that single location. However, if we have only one other person at that single location, then we're still missing a third person. Is that not correct?
No, essentially, and you can supplement this point, Ms. Michelle and Mr. Larson. Essentially, what the ADA is saying is that she's literally off the board, meaning she's here. Whether she's in Temecula, whether she's in Compton, or whether she's in Costa de Casa, she is literally sitting on the dais.
Right.
Okay, which means I could then come in remotely under just cause, and she's still counted as the three. So if Pearman and Balakaplana here, she's the third, irrespective.
Right.
I want to make sure, are we on the same page, Mr. Larson and Ms. Michelle?
Yes, but I do think Ms. Thomas's point too is you still need to meet your quorum requirements. Otherwise, assuming that person is being treated as being in the room.
Well, now hold on now, 1 second, 1 second. But if Ms. Verdugo Peralta is deemed in the room pursuant to ADA, if two people are present in the room
Right.
and two people are remote, is that
You're
quorum?
good.
That's
You're
our
good.
quorum.
If only one person is in the room, then that's no question.
So Ms. Thomas's question is, so give us a scenario where Balakapalan uses just cause, I use traditional Brown Act posting, the doctor uses traditional Brown Act posting. However, the doctor and I are at conferences out of state. And then Mr. Pearman, he uses one of the other exemptions. So how would that work?
That's not a quorum.
Yeah, I mean, you're saying if you use the traditional teleconferencing, if the two of you at the conference out of state are using the traditional teleconferencing?
Right, but we're not on the government business, meaning
Right.
for other government agencies.
Right, then you still need to have a quorum that is present from locations within the district boundaries. And so in that case, somebody who's claiming the ADA exemption would be present for purposes of a quorum. And so would the person for just cause.
Okay, but the
So I
just
think-
cause, well, the just cause would need, if just cause is used, and then you have the ADA person is in the room, that we putting that to bed, okay? If just cause is used, there still needs to be two other people in the chamber, correct?
The jurisdiction, right?
No, in the chambers, no, there's two, if just cause is used, two individuals must be in the hearing board chambers, correct? And then Miss,
In the jurisdiction.
no, under just cause is in the building,
That's right. In a single location.
in a single location. Now, let's talk about the jurisdiction, just so we're clear now, what provision is that? We're talking about jurisdiction.
That one is for the traditional teleconferencing requirements.
Okay, I mean the old Brown Act.
That's right. A quorum must participate from locations within the district's boundaries.
Michelle, when you said single location, that's not the same as saying the hearing board room, correct?
That's correct. I mean,
Because essentially, if three of us met at LA City Hall, we're in the same room,
yeah,
right?
Which we've done that where Mr. Pearman and I would be in the same room, or you and Mr. Pearman have been in the same room, right? And then now you're counting this person as here, present. It could be present with 1, 2, 3 of y'all in the same room. You have a quorum and you have everybody in a single location.
So Dr. Abraham raises a very good point. So if two people are downtown Los Angeles and Ms. Verdugo Parada's in Temecula, would she be considered a third in downtown Los Angeles?
so because the ADA provision makes you physically present, think of it like as kind of a roving person that you can move them around. So that person is considered kind of present where the other people are. So that's my best reading, is that person, that then if she was participating from Temecula, you have 2 at downtown City Hall, then you have 3. that are-
No problem, man. I understand. She's like the president of the United States. Wherever Air Force One is, that's where she is.
Yeah.
No problem. Hey, any additional questions?
Ms. Michelle, on that point though, so then in that case, there are 3 people present in Los Angeles. 1 is by ADA. 2 people are just absent. You do have a quorum. They can continue and no one is in the hearing room except the clerk. Is that a legal and appropriate meeting of our hearing board?
Yes.
Thank you.
So,
Mr. Balakapalan, floor is
I'm
yours.
looking at the language, the 54953.8.3A. It says that that participates in person from a singular physical location, clearly identified the agenda. A quorum should be of the members, so should be present at a single location. So are we saying now, as long as there are 2 people and 1 ADA approved person, that's okay, that meets the quorum requirement at a single location? Because it clearly says it has to be a quorum at a singular physical location.
Right. So again, this goes back to like the section in the ADA accommodation, where the remote participation counts towards the quorum as if the person is physically present. Because otherwise, I think you would have a situation where actually the statute would be backdoor imposing a higher quorum requirement.
Well, I can see, because the person is still within the jurisdiction of the agency and will meet the quorum requirement if there are 3 people. Forget about, voting on I guess, let me back up a little bit. Is there a need now? Previously, we had the emergency circumstance and the just cause, and you had to vote on the emergency circumstance. Now it's rolled into all the just cause. Do you still have to vote on that, or just a member has to say, I'm using a provision of just cause and leave it at that? Is there a need for the members to vote?
The second thing you said, it's just announcing it.
Just announce, that's it. Okay. So now then, let's say that there are only two people here at the board and one individual is using just cause. And so physically, there's no quorum at one single location because the other members is floating as an ADA. And that's okay? Is that what I'm hearing?
Right.
Okay.
I do-
Ms. Thomas, floor is yours.
Okay, under that scenario, though, if there's two of them participating, it's LA City Hall. Ms. Verdugo Peralta is the ADA, so she, would be considered as part of that three at the physical location. But does that location need to be posted on the agenda? Or is that, they can both be participating under just cause, so that location is not even being posted
You mean my location?
and open to the public?
Well,
No,
so-
not you, no.
I would say one scenario for sure, Mr. Pearman and I are at LA City Hall and we did post appropriately in the agenda and we're counting Miss Cynthia as present. Then that's three people and a quorum, and Mr. Balagopalan and Chair Ali are not present at all, right? So now your question, I don't know how to answer that one, Miss Michelle. If we're actually saying two are just cause and in a different place together, and you've got one ADA and two absent, do you have a quorum, and is that a meeting that could be legal?
Give me just a moment. I don't want to give you the wrong answer here. I mean,
Can I just say something as a general proposition while she checks that out?
Go right ahead, sir.
I just think it's probably risky to stretch this too far and to kind of say that two people can meet somewhere other than here as a teleconference location and then use a ADA call in to make that the third person in a single location. You're really trying to stretch the law. I think if you did not list that teleconference location as the place the meeting will be held, I think you're taking a risk, and I'm not sure it's really worth it. So I'm not sure we should try and take too much quote unquote advantage of this floating location of the hearing board member using ADA. I think generally speaking, that should be tied to Diamond Bar unless the notice clearly says otherwise, that this other place is where the meeting will be held in person today.
Well,
I
I'm
do
with you,
agree
but
with
the
Mr.
only
Mayor.
concern is that is a likely scenario. And so because this is brand new to us, right? And as a matter of fact, I've never seen this in 22, 23 years, right? And so two of us could find ourselves in a location. It is a likely scenario. Mr. Balakapan, you were going to say something?
Well, I was just going to, following up Mr. Pearman, if I'm the ADA, I don't want my, more than likely I'm doing from my home. It shouldn't be noticed that my location shouldn't be.
Never would
No,
be.
It wouldn't be.
There's
Right,
no.
so they wouldn't know. Yeah, but let's say if I'm the ADA person, my home won't be listed, right?
No,
So we only, the list, and let's say the members, public will only see two here. The third person, could be anywhere.
right.
And I think that to Mr. Pearman's point, we're stretching, I think, in doing that, but
Well, I don't believe it's a straight, it's a likely scenario and because it's happened. You've had two hearing board members in a room before. It has occurred.
So I mean, the section I read earlier does say it shall be treated as in-person attendance at the physical location for all purposes, including any requirement that a quorum of the legislative body participate from any particular location. So I do think if you had two just causes at one place, the ADA person would make the third, you'd have your quorum. I would feel comfortable defending that if anyone challenged it. I think if you had two just cause in two different places, that's a different scenario. I don't see how you get a quorum out of that if that's all you have.
Ms. Conager-Macklin.
I'm dealing with this exact scenario for one of the clients that I have. And the ADA accommodation means, for all intents and purposes, she is present at the board meeting wherever the quorum is. So the client that I have is a countywide client. So they can be anywhere in the county, so long as there is a quorum. That person would complete or would comprise the quorum. Her ADA exception allows her basically to float in and out anywhere and treat her appearance as though she's physically present. So I don't want to get hung up on whether or not we have two other people somewhere else. I think what needs to happen in that instance is we go back to the basic rules. And if we have a quorum with those two people being wherever they are and this third person, then a quorum exists. If those two, if their participation is not together, then we don't have a quorum.
And to Mr. Pearman's point too, I think when we find ourselves in those positions, I mean, we've been really good about scheduling. We've gotten better about scheduling our calendar in general to reflect our availabilities. And have we ever rescheduled or canceled as a result of knowing that we're in these like more sensitive spaces where it could be perceived as stretching? How late can we cancel a hearing? The day of?
Well, for lack of quorum, yeah, you can cancel it.
At that time. So I feel like if the chair says, okay, fine, the public's going to perceive this as stretching the rules, and we have two members out sick, two are going to try their best to get together somewhere else, and we've got one ADA, it may be some situation where we say, let's reschedule this hearing, right?
Mr. Pearman?
Well, actually, your point is well taken that we generally try not to cause problem. Like you came in on a rush basis because we had to. So I think you're right. In practice, we try and avoid having to dance on the line, so to speak, and we should continue to do so. And the other thing is, remember, unlike other entities, as the chair said, we've got alternates. So, you know, the simple solution is just use an alternate more when you have this issue. We shouldn't have this problem at all.
Correct.
Any additional comments, Mr. Balaka?
Well, I would think then also maybe during the meeting, then the ADA person should say, I'm within the jurisdiction of the agency.
No,
you know.
no, you
No?
can't. No, the law is clear. They can be in Munich. They can be in Kazakhstan. It doesn't matter. Yes, right, the ADA protects that.
So you don't have to be within the jurisdiction?
No,
Oh.
no.
So,
That's
okay.
done.
So so let's say I'm the ADA person and I take a extended vacation
Yes,
in Barcelona. I can do it from there.
Yes.
As long as
yes. The law is very liberal, which is one of the reasons why we're having this discussion. When we're going to get to the next phase of the discussion is looking at the policy and the amendment. But to your point, Mr. Balakapalan, yes. And as a matter of fact, I mean, I've been elected for many years and I've just never seen anybody utilize this. So again, this is something that's rather novel to me because of the liberality.
And Ms. Michelle and Mr. Larson, to Mr. Balagopalan's example, they're in Barcelona. That does count as present and in the room, correct?
There's no prohibition against that counting as present in the room.
That's clear.
All right.
I really
go
do
ahead.
appreciate this discussion though, because we are in this unique situation, you know, with Ms. Cynthia Verdugo Peralta. And so I think the question was always, are we in the room or not? Do we count them towards these numbers and quorum? And I think today we're going to leave here very clearly that we have Ms. Cynthia Verdugo Peralta in the room and or where the quorum of individuals are. And I think that puts at least that concern to rest, hopefully.
All right. So Mr. Larson and Ms. Michelle, let's move on to the grand finale, the coup de
Okay.
grace.
These provisions make, is there another question, Ms. Verdugo Peralta?
No, I'll go right ahead.
Okay, the provisions make clear that the board needs to make reasonable accommodations both to members of the public to appear at your meetings and to a board member who wishes to appear remotely. I'll note that your staff, your clerks have already been putting the instructions for the public on their agendas and on the website. That's all taken care of. You guys have been doing that great. This proposed policy that was provided to you yesterday and made available to the public yesterday is an internal policy concerning particularly a request from members of the hearing board who wish to appear remotely pursuant to the ADA provisions. And since you already have a copy of it, I believe, and the public has access to it, I'll just talk through the highlights. But essentially, requests are made in writing. Email is fine to the chair. If the chair is the one making the request, then the chair would make the request to the vice chair. The person making the request would have to put a minimal amount of information to allow the chair to make a determination whether the disability rises to the level of a disability as defined under the Americans with Disabilities Act. We have provided at the back end of this internal policy a proposed form that would help both the individual making the request and the chair receiving the request. The policy states that a request doesn't have to be for every single meeting, but can be for an ongoing disability. And the request and approval would last for a period of 12 months, at which point the person making the request would then need to submit a new request for the next 12-month period. It also obligates the person making the request to notify the chair if there are material changes in the requester's condition, meaning perhaps the disability is no longer in effect. And all this is maintains confidentiality, so this information does not become public. The chair keeps it confidential, and that's about it. And so there's a form at the end too. And I think at this point we'll just open up if you have any questions about the policy. I will note too, this is an internal policy governing board member and chair and clerk only, and so we do not think this is something that goes into the hearing board's public-facing handbook. This is a internal policy maintained by the clerks.
Members of the hearing board.
I had a
Mr.
question.
Balacaplan.
I know it requires the chair's approval, but the chair is not a medical person. Should the risk manager at the AQMD or somebody be one who should be looking at that and letting the chair know, hey, it's okay. I've reviewed it. Because it is possible that individual may need accommodation elsewhere. Maybe if they're coming physically here and they're considered having ADA compliant needs, then they should also make the provision to be able to accommodate them over at this location or wherever they're going to be, So because normally the risk manager here looks into that,
I mean, what you're asking is essentially a policy question for you all to deliberate and determine.
No.
Essentially, it's really a legal question of whether someone's disability qualifies or not, and so the chair could confer with counsel too on that question.
Ms. Verdugo-Prauta.
To Mr. Balacaplan's point, I was fortunate enough that they were already doing that when I was coming into the AQMD location. If you look at my chair is a specific kind of chair that accommodates a disabled person. And anything that they could do, including providing the guard, as you all know, Percy, who would put me in a wheelchair and roll me from the car into the facility and back again. So I have to say AQMD's been very cognizant of what I needed to be able to be there, as difficult as it was for me. And then when it stopped was when I had the knee replacement surgery, that my surgeon said he didn't want me in the car for that amount of time. And I'm probably saying more than I should or have to, but I don't mind. I'm an open book as far as that's concerned. But I think what Mr. Balacaplan also is making a point of is who certifies that that person is truly disabled. Is there a requirement from a doctor that has to sign off on that, or is it a self-certification? I understand what he's asking, and it's not written in there, so I would assume that it's not required.
Correct. And any sort of doctor's note is an optional thing the requester can submit. It's not required. And the policy states if the chair needs more information or clarification, the chair can go back to the requesting member.
Mr. Balacaplan.
I think my point I was trying to make is if the chair, let's say I got involved in an accident and I need ADA compliant, and I send it to the chair, and the chair approve it. But risk manager here doesn't know about it, because it's kept confidential. And so he cannot make accommodation like that was done for Cynthia here to accommodate my needs. So how do you address that? Or does the, if I plan to come in, what about accommodation? Is there a separate request then we have to make to the risk manager to do that?
Yeah, certainly the person, with an ADA disability can pursue all avenues available to that person to get accommodations, which could include working with the risk manager. I mean, this policy is really specific to remote appearances. And the confidentiality says, it's disclosed only to those who need to know. So if the chair determined that the risk manager needed to know or needed to be brought into the conversation, that would be something the chair could do as well.
Any additional comments or concerns? Dr. Abraham.
Yeah, I would just say, I think one important piece here is that we have to operate under the assumption that we are all working here in good faith, and that those that are going to use these provisions are legitimately requesting this of the chair, and we're making appropriate accommodations. And to Mr. Balagopalan's point, I think you separate those two things out. There's the decision the chair is making, and then there's also the operationalizing of accommodating someone with ADA request, which goes through another avenue. That's not this process, right? But I do think at the end of the day, we are here in our various capacities, brought here in various capacities, and we do expect from one another that we are operating in good faith and operating in the best interest of the public that we're here to serve. And I think if there are questions about that, then we need to continue dialogue with each other on those, because I do want us to trust one another and these requests and trust the decisions of our chair and our clerk and our staff so that we can get the work done.
Ms. Thomas.
No, I just wanted to add that, I will be letting our HR department know, because I know as far as employees are concerned, they do want to know if we're, when we're, working from home, because there's, liability type issues. There may be liability type issues. So I don't know if there's something they would need to do for anyone, a board member that's participating under ADA, or, if there's anything else they need to do, but I'll just let them know just in case there is.
So the way I see this is just very simple. This is not real difficult at all. The chair, whoever the chair is the head of the department of the hearing board, as it were, because the hearing board is self-governing, and there's no boss above the hearing board other than the EPA or the courts, the Cal EPA, et cetera, et cetera, et cetera. And then the courts, if you are going to go adjudicate a matter or decision for which the hearing board has rendered a binding vote on. So the notion of engaging risk management, I'm categorically against that. The chair would work in tandem, which is the case with the clerk's office via email. I want to underscore via email. Most of the communication I have, if not all, is via email. So it's very transparent. And so if there needs to be an accommodation for a member of the hearing board, comma, who are not employees of AQMD, comma, then we will make those accommodations accordingly. But I don't not necessarily believe that this needs to be in a very elaborate process. We can move forward accordingly based upon the same factors associated with how we've currently operated over the past few years dealing with Ms. Verdugo Peralta's challenges, or any other hearing board member who might also have medical challenges, or the need to leverage or utilize any provision of the Brown Act. It's pretty much where I stand. And I definitely would not be disclosing. If I'm the chair, I'm not going to disclose any information to anybody unless that member of the hearing board has asked that I do that, because that then opens up another issue. So we want to be very careful here, because we're in California, a very litigious state, and we want to respect people's medical rights. Dr. Abraham.
Yeah, my one concern about the, authority of human resources, for example, is that we are in such a gray space as not technically employees of the AQMD. And so when we deal with contractors, for example, that might be managed through a different process or purview versus the way HR might regulate or supervise or manage employees of the district. So that would be my one hesitation or reservation, is we're asking a body that doesn't necessarily manage or supervise your hearing board members, their opinion of this matter.
All right, any additional questions? Miss, why don't you come to the microphone, my friend? Come to a microphone. You can just sit right here. Sit at one of these chairs here. Yeah, there we go. And just state your name so folk will know who you are.
Can you hear me?
Yes, we can hear you.
Oh, thank you. Thank you, Mr. Chair. My name is Steve Samaniego, and I'm an alternate to this hearing board. And I just had a question on Mr. Balakapan's comment. I didn't completely hear Ms. Verdugo's Peralta's response, because my concern or wanting to know is there for the process of approving an application or whatever for the American Disability Act. I didn't know, Ms. Verdugo, is there a document that when anybody applies, so there's no trying to have a judgment called? Is there a document? Did you say there was one that was, if somebody's falling under the ADA, is there something that they have to show that they're meet the qualifications as the ADA? That's what I didn't completely hear what you were saying.
If you are asking me, Mr. Samaniego, I did hear that there is a form, and I believe it was Mr. Larson who may have
Yes.
mentioned it, that there's a form that I would have to fill out and submit.
That's correct. Yeah, this proposed policy does include a draft form that could be used for this purpose. And just to be clear, the form is limited to requests to appear remotely under this provision of the Brown Act.
Okay, and I guess that would be part of the this application form that is submitted, that form would be submitted as part of it, or is it not required?
I don't understand your question.
You said there was a form to be filled out to show that you or whomever is the person qualifies under the ADA. So there's a form that says this person that's applying meets the qualifications of an ADA. And so is that this form I was, oh, okay,
Yes.
then I rest my case.
Good
Thank
deal.
you.
Mr. Balakapalan, the floor is yours.
Yeah, just a point. It's the chair making the decision, not a doctor or anybody. And I also see, Mr. Lawson, you said if it's denied, the chair can deny it for whatever reason. Is there an appeal process in case somebody wants to appeal that, or is that the chair's denial final?
Yeah, it doesn't contemplate an appeal process there. I mean, there would be other avenues that we've talked about for seeking accommodations from the entity as a whole. I suppose they could go to HR or whatever else after that. But this doesn't contemplate any specific appeal process.
Dr. Abraham.
No.
Okay. Any additional questions or comments before we proceed forward with the action item, which is number 2? Ms. Verdugo Peralta.
Thank you, Mr. Chair. I just wanted to say to my fellow board members and to the staff there, everybody has always been so accommodating to me, Ms. Thomas especially, to get the equipment that I did need, but also my fellow board members, especially on that one situation where it was in a total emergency and somebody had to change their plans and come in because I couldn't. So anyway, everybody's just been great about this. I'm glad that it's finally in black and white and that we know exactly where we all stand on this. And I've been waiting for this for a while. I knew it was coming down the pipe. I just didn't know how long it was going to take to get there. I thought it was going to take longer, quite honestly. But everybody's been fabulous, and the attorneys as well. So I totally appreciate everybody's input as well as the accommodation itself. Thank you.
All right, Chair, entertain a motion to approve the internal policy regarding remote attendance in accordance with Americans with Disabilities Act and California Government Code Section 54953, subset C.
So motioned.
It's been moved by Ali, second by Dr. Abraham. Any further question or discussion on that motion? Hearing none, Dr. Abraham.
Aye.
Ms. Verdugo Peralta.
Aye.
Mr. Balakapalan.
Aye.
Mr. Perman.
Aye.
And Mr. Ali votes in the affirmative. The matter is hereby approved unanimously. Thank you very kindly for your participation. Thank you to the alternates who participated. We most certainly, it's always a pleasure to see your face, and thank you to all who were responsible for making sure that this day was very efficient. All right, at this time, Chair entertain, well, no motion. I move that we adjourn at 11 o'clock a.m. and we're off the record.
Have
Thank
a
you.
great
See you
weekend,
all.
everybody.
Bye.